Will now call 125740 in the matter of the wrongful conviction of Robert William Doelz.
Morning. May it please the court. Could I please reserve 5 minutes for my rebuttal?
5 minutes is reserved.
This case is about time. Time is valuable. Time is a resource that you can't spend, or I'm sorry, that you can only spend. You can't buy. And once you spend it, that's it. The state of Kansas took 4 years of Robert Doelz's life away from him. This case is about attempting to compensate him for that time. The statute itself bases the damages on the amount of time that the claimant was incarcerated. That's the background of this case. My client, Robert Doelz, is not a stranger to this court. In 2019, this very court overturned his conviction and released him from prison. It is that decision by this very court which has led the parties here today. Robert Doelz's appeal, admittedly, is on an extremely narrow issue. But I think it's important to lay out the foundation how we got here. In 2019, this court ruled that the state of Kansas illegally gathered evidence from a vehicle in which Robert Doelz was the driver. That evidence was deemed the fruit of the poisonous tree and could therefore not be used against Robert Doelz. Shortly thereafter, Robert Doelz's adjudication was dismissed by the Leavenworth County Prosecutor's Office. The search of his vehicle was illegal, and therefore his subsequent confinement and conviction were illegal. We are here today on an appeal of the trial court's ruling that Robert Doelz failed to show evidence that the reason for the dismissal of his criminal adjudication was because he did not commit the crime for which he was convicted. Where I believe all the parties in the trial court agree that the statute is poorly written. Now that we found some common ground, why don't we get into why we all disagree? The trial court and the state are incorrect in their interpretations of the statute, holding that resulted in subsection C means because of, and that it is the controlling word in the paragraph. When we look at the statute and we look at the plain language of the elements of the claim, the statute does not say anything regarding the reason behind the dismissal. The state and the trial court are attempting to read in the word because into the statute. The trial court holds that Doelz must have proven the reason for the dismissal of his criminal case was because he did not commit the crime.
Is that what they're saying, or are they just saying that and means and subsections B and C are joined by an and? So under B, you have a dismissal for whatever reason, but under B, you still have to show that the claimant, that your client did not commit the crime.
Yeah, and so I think that's where our argument in the state and the trial court's argument differ. We're not arguing that we don't have the burden of proof by a preponderance of the evidence that he didn't commit the crime. What we are saying is that the state's interpretation that we have to prove why his case was overturned is the issue. So they've argued that it's surplusage. B is you need A, B, C, and you're done. Well, C, subsection C, essentially states he did not commit the crime, he was not an accessory, and then it goes into resulted in, right? What we are arguing is that they're reading in this because definition to resulted in, right? They're saying that because he did not commit the crime, his case was dismissed. His case was reversed, or his case, or he was found not guilty on retrial. What we are arguing is that it does not. That's not the point of the statute. The point of the statute is to compensate people who are wrongfully convicted. And if we have to get into the mental state of a jury who made a claimant or granted the claimant to be not guilty, you know, it's something that is not contemplated by the statute, and it goes beyond what the statute is trying to convey.
Let me ask you a question. Number one, you know, we have to interpret the statute and we use the plain language of the statute. So let's just say that subsection C of 60-5004 stopped after it says that the claimant must prove by a preponderance of evidence that the claimant did not commit the crime. Let's say it just stops after that. Okay, so none of this because of that the reversal or the judgment was vacated or anything. What evidence is there? What evidence did your client present that he didn't commit the crime?
I think the only evidence in the record is the evidence we put forward. We didn't even get to the state's case in our trial. The only evidence was the evidence we put forward that, you know, his quadrant of the car was clear. A witness saw the backseat occupant of the vehicle the night before with the exact same parcel of drugs. The only evidence before the court, in the trial court, is the evidence we put forward of his lack of knowledge of the drugs,
Is that,
lack of possession.
but, I mean, we just in the previous case talked about possession.
Mhm.
It's his car, right?
It was his girlfriend's car.
Okay, and it's in the gas tank or whatever. I mean, that's possession.
Right, and we put forward evidence that he was not the person who pumped the gas. We had another occupant of the car testify as to who possessed the,
But it's like joint possession. I mean, he's driving the car. You know, I can't see a circumstance, you know, or preponderance of the evidence that he didn't commit the crime. I mean, you know, the whole thing is, I mean, he committed the crime, right?
no, and I think that's where we disagree with everyone is, you know, my client from the get has been saying that the drugs weren't his, right? And that he wasn't aware of the drugs, right? He
Right, but
testified
a
that.
jury found that he did.
Yes, and then, you know, subsequently that case was overturned.
It was overturned not because of sufficiency of the evidence. It was overturned because, you know, because of a collateral issue that had to do with an unlawful search and seizure, right?
I agree.
But on the underlying issue about whether or not the claimant committed the crime, a jury found the claimant committed the crime. Correct?
I would agree with that, yes. However, we've had a change in testimony from witnesses. We've also, you know, supplied evidence. I believe that after his criminal trial, there was a motion for retrial where people even said that the drugs weren't his. They came forward.
And was
witnesses-
all that
witness-
evidence presented at the civil hearing under 5004?
We had two witnesses testify, if I recall correctly, testify that the drugs did not belong to Robert Doelz and Robert Doelz himself. So the only evidence before the court before our case was kicked was evidence that we put forward saying that he lacked the knowledge or the possession of the drugs in the car. We you know, put forward evidence that he didn't pump the gas, and the last person to touch the gas cap before they were pulled over was someone other than Robert Doelz. That was all evidence that we put forward. And I don't even think the trial court kicked us on whether or not he did the crime or not. You know, we understand that it's our burden to prove under the preponderance of the evidence that he didn't commit the crime. What we're trying to say is that we were kicked because they wanted us to step into the mind of the prosecutor and say why his case was overturned, when the point of the statute is to compensate people who were wrongfully convicted, not, you know, derail them through the complications of court proceedings.
Well, why did the legislature include this language then? Resulted in a reversal or vacation?
So the state actually addresses that in their brief on page 8, where they talk about the Michigan statute. And so the Michigan statute talks about new evidence. And it seems that when Kansas, you know, sort of adopted this language, not sure if they adopted all of it or if it was something that they looked at, but the Michigan statute is alarmingly similar. The Michigan statute requires new evidence. And resulted in addresses new evidence. The new evidence resulted in a reversal, dismissal, or a not guilty verdict, right? If you look at resulted in the Michigan statute, it makes sense because it's addressing some new thing. When you look at the Kansas statute, it's gone. There's no new evidence to address, right? There's a verb without a subject. The resulted in is just there. You know, and in the state of Kansas admits it in its own brief that that's kind of how it is that it changes it. So what they're trying to do is read in a because to the did not commit the crime. They're saying that's why the adjudication needs to be overturned, is because they did not commit the crime, right? We're not saying that we don't have to prove that he didn't do it. We're more than happy to do that on remand. The issue is that we were kicked, you know, to quote the trial court, the reason for the dismissal was because because he did not commit, the reason for the adjudication was dismissed is because he did not commit the crime, right? That's what they are trying to allege. They're trying to make it so that the reason for the dismissal of the adjudication is because he did not commit the crime, as
Okay.
opposed to us having the opportunity to prove that he didn't commit the
Okay.
crime.
So in a case where you have a murder, a mass murder, or, you know, and there's one key eyewitness, and there was a trial error, I don't know, jury misconduct, something happened, and it is, it's reversed. We reverse it, and it's gonna go back down for a new trial, and the one key witness died. And so the prosecutor's like, I can't retry this case, so I'm not gonna retry it. And that person's been in jail, the mass murderer, for 4 years. So you're saying that, you know, even though it, you know, then you're gonna make that same argument that, even though that the fact that the claimant didn't commit the crime, even though that wasn't the reason, you know, for the reversal, then that person gets compensation?
I guess what I'm saying, and I understand where you're going, the question. But yeah, as the statute's written, that's how it would have
As
to
the way
be.
you interpret the statute.
As the way I interpret it, yes.
You're saying that
No, but the implication here is that any case that we hear, or the Court of Appeals hears, that is reversed, a conviction is reversed, and then results in either an acquittal at retrial or not a prosecution, basically ends up where you're at. Is that
Where the person has the opportunity to prove their innocence, and I don't even think it's innocence, it's actually, they did not commit the crime, yes. I think that's how it's written, and that's how it is, because they're reading in this because that shouldn't be there, because
as opposed to actual innocence? You got the wrong person.
it says did
Well,
not commit the crime.
I may just be confused. The way I understand your argument is that the district court committed a legal error by reading into the statute an element that is not there. That element is that the reversal of the conviction was because the defendant did not commit the crime.
Did that much better than I could, yes.
And if that's your argument, I mean, is that what happened? Is that what the district court did?
The district court, our case, because they said that we did not put forward evidence that his criminal adjudication was dismissed because he was innocent.
And can you like read from the district court's ruling or cite to where in the ruling specifically? Because I do think this is helpful to me, at least. I think I understand your argument. Your argument is not that one of the elements of your claim is that you prove by a preponderance of evidence that your client did not commit the crime.
So, because claimant has failed to prove a necessary element of his claim, there's no need to address these elements, right? Claimant did not offer any evidence that the reason for the dismissal was because he did not commit the crime for which claimant was convicted. That's their whole dismissal.
It just strikes me that that's a very simple argument, and you don't even need to get into this whole question about the second half of subsection C.
I think that's very,
Does
Is it-
does that render the second half of subsection C just surplus? We give it no meaning? We just, in essence, we strike it from the,
I think that you could possibly do that.
Well, isn't the meaning, I mean, I don't know, but Justice Standridge offered some pretty compelling hypotheticals, and it strikes me that this is aimed at preventing someone who procures the dismissal by illicit means. I mean, someone who hires takes out a key witness or something.
So I believe if it's subsection D or actually something where it says did not bring about his own conviction, did not suborn perjury.
Yeah, that's
you know,
the opposite. That's the, I'm gonna get myself convicted so I can later recover a huge sum.
Right.
But C is, again, I'll just posit this as a hypothetical possibility. It strikes me as it's possible that this language is aimed at preventing someone from recovering who, by illicit means, caused the conviction to be reversed, or caused there to be no charges filed after the reversal. That's the hypothetical I think was being discussed earlier of, you've caused a mistrial because you've tampered with the jury, or
and-
you've killed a key witness on retrial, or some nefarious act.
Yeah.
I mean, doesn't that make sense with the language in subsection C?
That scenario does make sense, but I don't.
It's not
think-
relevant to this case.
It's not relevant to this case, but it's also,
doesn't it require us to read into the statute something that's not there?
I think what happens beyond this case is a fascinating question for the statute. But what I think is happening is that because language, the reading in that they're asking you to do, while it's saying, not to say that it would necessarily be that there would be nefarious means to, I don't think that prevents that. The reading that they're doing is because they are trying to say that you have to get into the mind of the jury, mind of the prosecutor, mind of, the Supreme Court perhaps, who let this person out of jail in the first place, right? That's why the conviction was overturned. I think one of the big things in this case is, where I don't think the second half of the statute is surplusage, right, is because it outlines three paths to recovery, right? It outlines reversal, dismissal, new trial, right? Not guilty upon new trial. When you get to not guilty on new trial, it would make that possibility a legal fiction. It would make saying, okay, you got your case reversed and then you went to a new trial. The only reason you were found not guilty on new trial, is because you were innocent. No jury could ever deliver that. It makes that part of the statute nonsense, right? No jury could ever say you're innocent. No jury could ever say you did not commit the crime. The only commentary juries give us in America is not guilty. And so that's where I think, if they put these three separate paths in there that you can have after your adjudication ends, they must all be viable, and we must all take into account, that the same probable cause and same burden of proof has to apply to all claimants. right? You know, you can't look into the mind of a prosecutor who dismissed it and then, you know, say, okay, well, you know, you got retried, you're good. And it has to be the same burden of proof across all of them. And they put these in there, these possibilities in there, so they must be interpreted. We must interpret the statute in a way to make it viable.
But that also means giving some meaning to the word resulted. And I think that's the problem. To me, that's the problem because there's a word missing. What resulted? There is nothing that tells us what has to go before that causes the result, right? Because grammatically, it just doesn't fit with the first part of that section, nor does it fit with the umbrella language of A. Something is missing, but under your interpretation, what are we doing with the word resulted? Are we just ignoring it?
I think any definition of resulted other than because would require a remand in this case. Because unless it is because, and it addresses did not commit the crime, then any other definition besides that, we've hit all the elements and that would change the district court's ruling for why we're here, right? We are here on that narrow issue of resulted in means because. You know,
Is that even a legal thing? Like, to get reversed because the person didn't commit the crime? Not really a thing, is it?
doesn't sound right to me.
I mean, convictions get reversed because error was committed.
Right. And I think that,
Sufficient evidence.
yeah, and so it would make it
Is
nonsensical.
insufficient evidence the same as the defendant did not commit the crime?
No, and I think that's why we still have to go prove that. But, you know, I think the statute has to be interpreted in a way that makes sense, in a way that makes it fair. And if we interpret it their way, then really it makes it pretty difficult to state who can claim under this statute, because we would have to look into the mind of whoever issued.
Well, in your case, you wouldn't have to look into the mine. You could have just called the prosecutor.
So we subpoenaed him or attempted to serve him a subpoena before trial when I looked at it.
What if it means that it doesn't have to be that exact same crime, but it has to be same acts that led to the charges that led to the conviction? So what I'm saying is that it says the claimant did not commit the crime or crimes for which he was convicted, and not an accessory or accomplice to the acts that were the basis of the conviction that resulted in reversal. So it has to be, if you interpret it as the acts underlying the conviction and not the specific conviction.
With the because, is that what? Or just the
Doesn't mean
statute, or just
because.
with the statute?
It means that we're talking about the same facts that led to the charges that led to a particular conviction. But the meaning that the legislature is trying to evoke is not that it, because it resulted in reversal or vacation, but that it relates to those specific facts that eventually led to the conviction.
I would say that in response to that, I think that would still go back to, we still have the burden of proof.
But
right?
what if, for example, he was convicted of felony theft for stealing an emerald? Turns out that they didn't charge a lesser included of a misdemeanor, but it turns out that the emerald really isn't worth at least $1,500.
I think then you could, and that's interesting because different parts of the statute say different things as to whether it's the crime charged or whether it's not. And I would say that that would go into the burden of proof, that we have to prove that, yeah, sure, you don't have to prove that you committed the crime charge, but you can also, you know, you have to,
You have to prove you didn't steal the emerald. That's the point.
I would say no. That would be on the prosecution at the time of the case to charge you with that. I think there was already a case that was,
So you
this court's already ruled on that with a burglary charge. I forget the name of the burglary charge. Had legal access to the building, and they didn't charge him with the lesser included, and he,
Your point, you only have to you only have to prove that he didn't steal an emerald that's worth at least $1,500. You don't have to, so if you prove the emerald is worth less than $1,500, you get 4 years worth of compensation because you may have stolen the emerald, but it was only worth $500.
yeah, if we can prove that. I think that would be the definition that, based on this statute, works.
But if you read it the way that I just suggested, that subsection C requires you not only to prove that valuable emerald, you have to prove he didn't steal emerald, because that also could have been charged.
Yes, yeah, I believe that I'm agreeing. Because of the accomplice liability in that second part, you know, you have to say that he was. I think that does go against a previous ruling of the court where they didn't include the lesser included.
It please the court, Deputy Solicitor General Dwight Carswell appearing on behalf of the state. This statute is, as the district court noted, poorly written. But that doesn't mean it can just be ignored. It must mean something. The phrase resulted in is clearly referring to something must have resulted in either the reversal or vacation of the conviction, dismissal of charges, or finding of not guilty on retrial. And the only plausible interpretation is that resulted in is referring back to the first half of the sentence, everything that comes before it. In particular, the requirement that the claimant did not commit the crime. There is no other.
Is that, Justice Siegel, you're asking your question.
Yeah, I was
More-
gonna
In a
ask
more,
my
in a
same
more
question.
precise way than I
I don't know that
asked
it's
mine
very
earlier. but
precise.
You go
I-
first and I'll follow up if I need to.
The way I put it to your opposing counsel is that even a thing? I mean, that's not very precise, I guess, but I've never heard of a reversal because the defendant did not commit the crime. I've never heard of that.
Well, it doesn't mean that the appellate court would have to find that the person did not commit the crime, but that would be what was caused it. So the finding would be insufficiency of the evidence, or it could,
Insufficiency of the evidence is not, it's not a finding that the person. did.
that's what I'm saying. The appellate court would not need to find that, but if the person did not commit the crime, that would cause insufficiency of the evidence. That would be what's behind that.
Can never be a finding that that's the reason why there's insufficient evidence because the defendant didn't commit the crime.
Right, but what the statute is, the statute does not say the appellate court has to find that the person did not commit the crime. It says that the fact that the person did not commit the crime resulted in reversal.
Well,
So if the person did not, oh, go ahead.
Do you agree with what your opposing counsel, how your opposing counsel recited the district court's ruling in this case?
Yes, I would just say here it was not just about reversal. It was either reversal, dismissal of the charges, or finding
But
not.
you agree that the lower court found as a matter of law that for the claimant to prevail, he had to satisfy as an element that the dismissal was because he did.
One of those three things: reversal, dismissal, or the finding of not guilty, which wasn't an issue here.
How would any person ever meet that element if that were an element?
The third element, or any of the three?
Any of
So with the first one, as I was going before, I mean, if a person did not commit the crime, that would result in a finding of insufficiency of the evidence. Again, that's not what the appellate court finds, but that's causing that.
Let's just
that
say
because
that
there's-
let's just say everyone under the sun agrees for whatever reason that that a hypothetical defendant did not commit a hypothetical crime.
Yes.
That's unquestioned. But it's also clear from the appellate court decision reversing the conviction that the reason it was reversed was because of some constitutional issue that had nothing to do with it.
Well, in that case, then it wouldn't be satisfied by reversal, and then you'd have to look at the reason why it was dismissed. And if it was dismissed because, if the prosecutor says, well, I'm not going to go forward with this case because it's clear that this person's innocent, then you would show under
If the
that
prosecutor
provision.
never says, I mean, that strikes me as the state's taking a position that if your conviction gets reversed for any reason other than that you didn't commit the crime, King's X, you don't get to recover under this.
I mean, if it gets reversed for some other reason, like say, I don't know, ineffective assistance of counsel, then it goes back to the trial court. Then the question is, well, what happens at that point? I mean, if it goes, the prosecutor looks at it and says, well, I want to retry this case because I think the person's guilty, and it goes to trial and it's proven that the person's innocent, well, then that person could potentially, based on other things, recover. But if it's set aside for other reasons, like a Fourth Amendment violation, if the reason why the case does not go forward is because of these other reasons, then yes, they would not be able to recover. And we think that's not only the best textual reasons, as I'll get back to, but that's also, if you look at the legislative history, what the legislature was getting at, what motivated this law, where there were particular instances where people's convictions were set aside because it was determined that they were innocent.
Actual innocence.
Actual
That's what I'll
innocence.
follow up on.
Yes.
Did they accomplish that with this statute? Let's just say Mr. Dole's case got dismissed because of the Fourth Amendment violation. But it turns out he wasn't even there. It wasn't him. How does he get relief under this statute?
He would not if it was solely because of the Fourth Amendment violation. But again,
But he wasn't there. He's actually innocent. Served 4 years of his life in prison for a crime that he was nowhere around, had the wrong guy. Does he get relief under this statute?
if the reason for reversal and dismissal was solely the Fourth Amendment violation, then no. That's different than the situations which motivated the
It said
legislature.
the intent of the statute is to compensate people who were wrongfully convicted who are actually innocent. How do you get that?
Mr. Carswell, is an example like Lamont McIntyre, where either a wrongful eyewitness situation or DNA evidence comes up, and there was, where we didn't have DNA before, but then now there's DNA, and these are situations where there is actual innocence, just like under our habeas statute, where it is actual, the example being that he wasn't even there, that, we now have availability of technology to zoom in, and then you see, oh my goodness, he wasn't there. That's somebody else. Is that really what the statute is aimed at?
Yes, people whose convictions were set aside because of actual innocence, like Lamont McIntyre or the other examples, Floyd Bledsoe and Richard Jones, sorry. People that's the reason why their convictions were set aside, was because they were actually innocent, not people whose convictions get aside for other reasons and then later come in after the fact and say, now I'm actually innocent. And part of the reason why the legislature, I mean, that's a policy decision as to why they might want to make those distinctions. But one good reason to do that would be, well, now after the fact, if it's set aside because if your conviction's set aside because you're actually innocent, then that's already been established to some extent. If you're coming in after the fact, your conviction has been set aside for other reasons. It now no longer really matters whether you're guilty or not because your conviction's gone and the state can't re-prosecute you. And you're claiming that you're innocent now, and the state then essentially has to retry you in a civil case. Granted, it is your burden, but you just have to say I'm innocent, and then the state has to go and basically in the civil case put on a whole trial to show no, you're not. If they actually believe you're guilty, then that's putting quite a burden on the state. It's causing victims to have to testify again. So the legislature could reasonably make this distinction. I'm not saying whether it's right or wrong, but it's certainly a policy distinction that the legislature could reasonably make, and we think they did reasonably make, and say this statute is only available to provide compensation to people whose convictions were set aside because of finding of innocence,
Doesn't
not,
that render surplusage the language in the statute that requires the claimant to establish by preponderance of the evidence that they did not? I mean, if you've already got if under subsection B, you have your conviction reversed because you're actually innocent, why go through the pantomime of having to prove by a preponderance of the evidence that you didn't commit?
I mean, I suppose it could be because maybe a prosecutor thinks in some situations that, like, hey, I think this person's innocent, so I'm not going to go forward with this prosecution. But then in a later case, they come forward and maybe at that point, there's additional evidence that they actually did commit the crime. So the state at that point is saying, well, you know, even though the prosecutor dismissed the charges because we think you didn't commit the crime, actually, it turns out on further discovery that we think you actually did. So we don't want to provide you your compensation after all. So there could be some gap there. I will also note that this statute does appear to be modeled after the Michigan statute that we cited in our briefs. There's nothing directly saying that, but there is this statute, including this language as it was originally introduced at the request of the Innocence Project. And the Innocence Project testified that this statute reflects the best of what other states have done. So we know at least parts of the statute were modeled on other states. And then the similarities between this statute and the Michigan statute, these particular provisions, not overall, but these particular provisions seem similar enough that it's just too much of a coincidence to have been random. And the Michigan statute does use the phrase new evidence that shows demonstrates a person did not commit the crime, and that new evidence must have resulted in dismissal or reversal or these other things.
That's not in our statute.
Exactly. And then this statute takes out the new evidence language, but it does still require a person to prove that they did not commit the crime by some evidence, by preponderance of the evidence.
So let me ask my textual speculative question, I guess, which is, we're focused on subsection C. It seems pretty clear to everyone that it's hard to make sense of it. If we just change, not we, but if hypothetically, if you were just to change the word "and" between the words conviction and resulted to an "or," does that make the whole thing make sense?
I don't think so, because then the resulted would be referring to back to
In other
acts.
words, let me just run by what I'm thinking. The first part of this goes to Justice Wilson's question, which is, even if you are innocent of the actual crime, you still can't recover if you still did something bad. You stole the emerald that was a fake emerald, it turns out. You can't recover. You're an accessory or an accomplice to the acts that were the basis of the conviction. And then if there's an "or" there, that last part, to me, suggests the legislature not wanting to let somebody recover who did something that interfered with either the prior trial or a second trial. That was Justice Standridge's question.
I don't think so, because then the "or," I think that would more naturally make the resulted in, I mean, it would still, what's that referring to? The acts that were the basis of the conviction, but
No, acts
being the
acts
accessory.
that resulted in the reversal. You could just strike, you could read the sentence, just take out the words that were the basis of the conviction. Or I'll just read it. Was not an accessory or an accomplice to the acts that resulted in the reversal or the vacation of the judgment of conviction. That makes sense to me. Am I wrong?
doesn't make sense to me, because I'm not sure the acts that resulted in the reversal would be, I mean, showing you were innocent, essentially. I mean, what caused the reversal would
What
be.
if your friends tampered with the jury? And it's the conviction's reversed on appeal. Then you are responsible for, you're an accessory or an accomplice to acts that resulted in the vacation of the judgment of conviction. The legislature saying, nope, you don't get to recover under those circumstances.
Perhaps I'd have to think about it more. I mean, I do think, though, I mean, the "and" was what was obviously
Yes,
chosen by
that's
the
what's there,
legislature.
so we're-
And also, I mean, again, I think this is copied from, it appears, from the Michigan statute. So, I mean, I think you'd be radically changing from what the Michigan statute means. Whereas our interpretation is most consistent with with what they copied from. I think also to the extent you think some word is missing, I think what is implied here essentially, as we put in our brief, is essentially a this before resulted. So if it's and this resulted in, so you have to show the claimant did not commit the crime and this resulted in, that's essentially what the statute is reading. So if you have to actually read words in, I think actually this is essentially applied, but to the extent you're reading words in, that's the way to do it, to be both consistent with legislative intent, especially again with what happened in terms of how they modified the Michigan statute to adopt it in Kansas, rather than changing and or, which I don't think there's any evidence that that's legislative intent.
In other words, the claimant did not, the not committing the crime resulted in the reversal or vacation is how you get us there grammatically.
Yes.
That to the interpretation, which I understand that you're advocating.
Yes.
Okay.
And that is how the district court
That's how the district court
construed
interpreted
the
it.
statute.
Yes. Yes.
And do you also agree with the argument of counsel that under his alternative interpretation, there would have been error, that because there was evidence presented that under the standard that applied to the district court, viewed in the light most favorable to the plaintiff, would have shown innocence?
So the district court did not actually address whether the claimant committed the crime, just because this was a state moving for judgment as a matter of law.
Okay, well, but there was evidence presented. Or under on the opposing interpretation.
Doelz put on his case. The state had not put on its case yet at the time that the district court granted
Right.
judgment as a matter of law. So I
Right.
think we would have contested whether the district court should have found that he'd met that or not. So we don't know what the district court would have found by preponderance of the evidence as to that point, as to whether he actually was innocent or not. I think our position would be no, he's not actually innocent. But regardless.
The evidence that he presented was not sufficient
Yes.
as a matter of law to show innocence?
It's a matter of fact to show innocence.
But the conclusion, well, yeah. But the standard would be that evidence that was presented as a matter of law could not have demonstrated the claimant did not commit the crime.
Maybe I'm not following you. So at the trial, what happened was Doelz called a few witnesses, and
Right.
one of them saw some of the testimony. I haven't gotten into it too much because that's not what the district court decided.
Right.
Was basically that this was someone else's marijuana. He didn't have knowledge of it. That's contrary to what the jury in the first trial found, of course, and the state had contrary evidence. So that all would have been something that would have needed to be determined if there actually were a full trial and at the end of that.
Yeah, had there been a full
Yeah, yeah,
trial, but which obviously didn't happen, but I was just trying to get to the standard of review, I guess, that would have controlled under his interpretation of the statute. At that point, the time of the trial, the judge should have, if under the competing interpretation, you would just look at his evidence in the light most favorable to the plaintiff at that point in the proceedings.
I mean, I think if, under his interpretation, if you essentially just ignore the second part of the subsection, which is what I think he's essentially arguing for, and just look at whether the claimant committed the crime or not, then that's a fact finding that the district court would need to do. And because the district court's acting as a fact finder, it would be essentially a sufficiency at the evidence review by this court. Yeah. One other point I just wanted to make before closing, I see my time's out just quickly, is to the extent there is any remaining ambiguity, and it sounds like the statute is very confusing, you do need to keep in mind that when the state waives sovereign immunity, those waivers need to be construed strictly. So if there is ambiguity, that needs to be construed against liability here and not broadly to require the state to provide compensation.
Was there a case cite for that proposition?
There was one Kansas case, Brown versus State Highway Commission, and then several federal cases were applying the same principle that flushed that out a little more.
And that's in your brief.
Those are in the brief, yes.
Thank you.
Sure. Was there any further questions? Ask that you affirm the district court. Thank you.
You.
Counsel, I'll just jump right in since we just talked. What would your response be to what State's counsel just said at the very end there, which is that if there's an ambiguity, constitutional considerations require it be construed against liability.
In regards to sovereign immunity, the statute itself is a waiver by the state. Statute itself is the state waiving
Right, but
liability
it's,
on this.
I understood the state to be making an argument, like a rule of construction argument, which
Mm-hmm.
is because there's these constitutional concerns, as a rule of construction, we would construe ambiguous statutes against a finding of liability.
Yes, and I don't have a case to dispute that. However, I think where that applies to this case is that we can still look to the statute, and the definition that they want is not asking this court to construe it against liability. It's construing it to make it not make sense. Regardless of liability, it's construing it to make it nonsensical. And that's why. So for construction purposes, I do think that the statute should be narrowly tailored, like the state says. However, I think that it also has to be construed in a way to make sense. And, it's not part of my brief, and I apologize, but I had anticipated some questions this morning. At its heart, the test for vagueness is a common sense determination of fundamental fairness. So I think statute's vague and it doesn't make sense. But I think we also have to interpret it in a way that makes sense and is fair to every person who would bring a claim under the statute. And I understand that our interpretation would mean that there are a lot of potential claims. But we still have to interpret it in a way that makes sense. We talked a lot about the intent of the state. Well, I can intend to eat a salad for lunch. When I get to the restaurant and I order a meatball sub, my cardiologist have to deal with the actions that we took, not the intent of me gonna eat a salad. I don't get points for the intent, right? So when we look at this, they intended it to be actual innocence and all of these things. They didn't put it in the statute, right? They didn't put, innocence doesn't occur until we get to, the word innocence doesn't appear in the statute until you get down to certificate of innocence, bottom. It doesn't talk about that. It talks about not commit the crime. And then when they put the words in there in subsection C, they made it to be nonsensical. And so we're asking, the court to remand us with a definition that it's any other word but because, and it makes sense, right? But this because makes the whole thing surplusage. And it makes it nonsensical, and it makes it for a claimant who might well, not have committed the crime, right? Regardless of how he gets to this point, unable to claim under this statute. I think your analogy earlier, makes sense where, right, what if Robert Doelz wasn't even in the car that day or something along those lines, right? But he got dismissed because of a Fourth Amendment violation. Well, you can have your case overturned by a Fourth Amendment violation and still be innocent of the crime. Like, the two are not mutually exclusive. You can do both things. A claimant can be both things at once. It's not you're innocent, but we violated your constitutional rights. It can be both. And I think that is why I'm here, and that's why we're going through this. And I want to thank the court for their time on this bizarre issue and this really thorny legal issue. And I appreciate your attention to it because it's, a younger lawyer, but this is the most bizarre statutory interpretation I've had to deal with so far. And unless if there's no more questions, I'll yield my time back to the court.
Thank you to both counsel for your arguments. The court will take this case under advisement.